Hi everyone, and thank you for joining today. So welcome to this afternoon or this morning's webinar, depending on where in the world you are right now. And we're going to be talking today about responsible AI in recruitment. I'm Moira Campbell. I'm a director in the employment team at Fieldfisher, and I'm currently based in London, although I'm planning to move out to the Silicon Valley office shortly. I'm joined today by my excellent colleagues, Richard Lawn, who's a senior associate in our data team, and he's got specialist expertise in AI and privacy. And I'm also joined by Hannah El-Ghazar, who's a trainee solicitor in the Silicon Valley team. So why are we talking about responsible AI in recruitment today? Well, employers are increasingly using AI-enabled tools in recruitment to automate and simplify existing processes. And this can enable greater efficiency. It can cut costs, and it can also improve consistency by applying objective and data-based decision-making to workforces. However, this is not without risk. So running applicant data through AI-powered features and using AI tools to make decisions in the recruitment process can give rise to issues of data protection, discrimination, and bias. And this can escalate into legal disputes. So here is a snapshot of our agenda. So firstly, we'll identify the key legal risks and the legislation which should be taken into account from an employment law perspective and from a data protection perspective, and take this into account when you're procuring and deploying AI recruitment tools in the workplace. We'll then outline some considerations for using AI during the recruitment lifecycle, and during that phase, we're going to focus on some specific tools. And finally, we're going to provide some practical tips and some key takeaways for best practice. And feel free, please, to ask questions at the end, and also be ready to use Slido from time to time, as we'd like to gain your input during our session. And in fact, Richard is going to use Slido with you now.
Yeah, thank you, Moira. So let's dive straight in. We're going to present a Slido question for you. If you're not familiar, you can scan the QR code that's on screen, or you can even go onto the Slido website and input this code to take part. So get out your phones and get ready to do some polling. So the first question we've got: are you already using AI in recruitment? We just want to do a quick poll to understand how many of you are already actually using AI tools and software within your recruitment processes today. We've got some live answers coming in already. We anticipate that a lot of you probably are using AI already. And let's not forget, AI is also a very broad term, right? So that can include all sorts of different types of software and tools. It doesn't just necessarily relate to some of the more recent advancements in generative AI and chatbots, but it could include all sorts of different tools, which we'll come on to talk about a little bit later on. So taking a quick look at the poll so far, we've got pretty clear indication that most of you are already using AI in recruitment, 50% of responses. And some of you, quarter, saying you're considering using it. So that's a good time then, I think, to be tuning into this webinar to hear about some of the risks and legal issues to be considering. All right, so with that said, let's talk about what are those relevant laws and regulations. And here we're just going to give you a snapshot of some of the most relevant laws that you'll need to be thinking about. And Moira, I think you're going to kick us off by talking through employment.
Yes, thanks, Richard. So yeah, firstly, looking at relevant employment law in the EU, and so there's currently no AI-specific employment legislation. So the use of AI must be assessed in the context of the existing UK and EU legislation. So equality and anti-discrimination legislation is of key importance when using AI in recruitment, and also when using AI in the workplace more broadly. There's a risk that AI tools can produce discriminatory outputs, and this can be either as a result of misuse by the individual using it, or it can be due to the limitations of the tool itself. And key legislation to be aware of includes the EU Equal Treatment Directives, and they need to be transposed into national legislation by each member state. So in the UK, there's the Equality Act 2010, and this provides various protections against discrimination, such as protection against direct and indirect discrimination, harassment, and victimisation on the grounds of any of the 9 protected characteristics, such as age, disability, religion or belief, race, etc. And this protection from discrimination extends to candidates who are applying for roles and they're not yet employees. So it will apply in the recruitment context. And claims can be brought, and they are brought, against employers for allegations of discrimination in recruitment. So this could be, for example, a candidate alleging that they weren't selected due to their protected characteristic. And the risk of unfair bias and discrimination is inherent throughout the recruitment process, so right through from sourcing, screening and interviewing and at selection. And disabled people in particular may face disadvantages. So for example, some systems used at interview, they might read or assess a candidate's facial expression or their response, or it could assess the level of eye contact, tone of voice, language, etc. And this could disadvantage candidates with visual or hearing impairments, or neurodiverse candidates, for example. And it's worth bearing in mind that there's a legal obligation for employers to make reasonable adjustments or accommodations for disabled individuals, and that's to remove the disadvantages for disabled people. And please note there's a very wide definition of disability in this context. There's also other employment legislation which is relevant to using AI in the workplace more generally, but it's not going to generally be applicable in the recruitment context. So today we're going to focus on equality and discrimination rights. So Richard, what are the key data protection legislation to be aware of?
Well, just as employment laws exist today and they apply generally within employment and recruitment context, we also have data protection laws as well. And let's not forget, these laws are going to apply whenever you are collecting and processing people's personal data, which is going to be inevitable at various stages of the recruitment life cycle, at the point where you are sourcing your candidates, when you are assessing them, and then also when you're onboarding at the final stages as well. So in principle, in Europe, we have the GDPR, we have the EU GDPR and the UK's own cut and paste version of the GDPR that was incorporated into UK law post-Brexit. And really the GDPR is that generally applicable law that's going to set out some core principles that apply when you are collecting and processing personal data. Think about things like the need to provide notice and transparency to candidates about how their data is collected and processed. Also thinking about fairness principle, that the use of the personal data is fair and considering the potential impact for their privacy rights. And of course, we also have a number of specific rights under the GDPR for candidates, the right to access, correct, and to delete their data. We'll come on to talk about those things a little bit later on. But importantly, to remember that the GDPR doesn't apply specifically to AI, but it's going to become relevant in any context where AI tools and systems are used in the context of processing candidates' personal data. But that said, we also increasingly have a number of AI regulations which are more targeted and focused on the use of AI. And I'll hand over to Hannah now, who's going to speak a little bit more about that.
Thanks, Richard. So now we turn to the EU AI Act. The Act has now been formally adopted, and any day now we're expecting it to be published in the official journal and the law to be applicable. So the Act essentially categorizes different technologies based on their level of risk, ranging from prohibited, which would see the technology banned, to high-risk systems and limited risk systems. The Act classifies AI that's used in the workplace, including for recruitment purposes, as high-risk technologies. And this includes tools used for reviewing applications and making decisions in the recruitment lifecycle. So this will have significant consequences for providers and deployers of these tools. And this includes a range of stringent compliance requirements, such as governance mechanisms, risk assessments, human oversight, and transparency requirements. The requirements for high-risk systems will take effect 2 years after the AI Act comes into force, so there is ample lead time before these requirements become relevant. But during this period, we expect codes of conduct and standards to be developed. So whilst we still have plenty of time to prepare, businesses need to keep track of how this continues to progress. And now we turn to some proposed UK bills, and continuing with the theme of AI, we've got the UK AI Bill and the TUC AI Employment and Regulation Bill. So the UK is in the midst of creating its own AI legislation to, of course, regulate AI, but it's only at proposal stage at the moment, so we shouldn't get too excited, but we may see this getting pushed back further due to the general election in the UK taking place over the summer. The Trades Union Congress has recently published the AI Employment and Regulation Bill, which is intended to strengthen workers' protections by, amongst other things, imposing safeguards on automated decision-making and amending existing equality legislation to specifically cater for algorithmic discrimination. It also proposes a new statutory union consultation right, extensions to employee dismissal protections, and improved employee data access rights. Clearly, we're at an exciting stage where we're seeing increased regulation of AI across the UK and Europe, so we need to continue to monitor how these progress.
Wonderful. Okay, so we've talked a little bit about the laws that you'll need to consider. Now we're going to come on to our second Slido. So again, get your phones out or hop onto the Slido website. What do you perceive as the biggest risks when using AI recruitment tools? So this might be based on your own experience to date for those of you who have already implemented those tools and software, or maybe this is based on what you've read or particular risks that you know about and are thinking about before you start to introduce these tools. Okay, we're starting to get some answers coming in. Discrimination featuring quite prominently. False promises, little value. That's a really interesting one, right? We're seeing a lot of hype around AI and its capabilities. And you know, sometimes it lives up to those promises, but sometimes maybe it falls a little bit short. Automated decision making, incorrect outcomes, and results-based hiring. Yeah. So I think, you know, there's going to be a range of different risks, and some of those are going to be legal risks. So, you know, non-compliance with employment laws and data protection laws, violations of anti-discrimination legislation. But also there are going to be some commercial and operational risks too. And I think some of the examples on screen are touching on those. So thinking about, you know, things like integration. Are these new tools actually going to integrate well with existing recruitment and HR systems, or potentially could they lead to inefficiencies and increased costs? Could there be talent misalignment? So for example, maybe the software doesn't effectively capture some of the nuances of what makes a candidate a good fit for your organization. So actually could, you know, lead to poor hiring decisions. There are a broad range of different risks. And let's not, of course, forget reputational harm. So we've seen a few news reports in the last few years about companies deploying these kind of technologies, either in non-compliance with the law or that raise broader ethical and social issues. And that causes them to be featured in the news, and unfortunately not in a good way. So there's all sorts of different legal, commercial, and reputational risks that we might see. Of course, when we're thinking about these risks, though, we also want to be thinking about, well, how do we address them and how do we ensure compliance with our legal obligations? And rather than going through, you know, very prescriptive and detailed analysis of all of the laws, this slide presents some of the key principles that you need to bear in mind when you're implementing these technologies. And these are principles that are common across all of the different rules and regulations that we touched upon earlier. I'll hand over to Moira now, who's going to kick us off by talking about this transparency principle.
Thanks, Richard. So yeah, transparency is a fundamental principle, which I'm sure you'll all be familiar with. And in terms of AI, businesses need to ensure that the use of AI systems in recruitment is clearly signposted to candidates. And this needs to be done prior to the launch of the system and in advance of their data being processed. And this will include providing information on the system's purpose, as well as any limitations and how those limitations might apply to individual applicants. So, for example, you can provide detail in the job advert or in the job description, or you could provide a disclaimer on the use of AI next to, for example, the upload CV button on the application form. And this will enable applicants to request reasonable adjustments, which I mentioned earlier, and allow for contestability and redress. As obviously it's not possible for candidates to exercise those rights without knowing that the system is being deployed. And your recruitment privacy notice should also refer to any use of AI. So it's also important to understand the AI tools that you're using as far as possible to ensure that you can be transparent about how a decision is made and mitigate against the risk of inherent bias or discrimination. And this is particularly important where AI is used for automated decision making, because the GDPR requires you to provide meaningful information about the logic behind the decision. And AI models often use complex learning and decision-making processes, and they're not always easily interpreted by humans, making it sometimes difficult to explain how a decision has been reached. So if the candidate who is affected by the AI decision or the human decision maker don't know how the decision has been reached, it's difficult to identify the presence of bias or discrimination in the decision. This could theoretically lead to employees raising what's known as protected disclosures relating to unlawful processes. So that could in turn give rise to not only discrimination issues, but it could also give rise to whistleblower protection. And that's a sort of theoretical risk at the moment. Where AI tools make decisions about employees rather than applicants, but employees, then a lack of transparency could lead to a breakdown of trust and confidence in the working relationship, and that could risk a claim of constructive unfair dismissal or breach of contract. So it's really important to be transparent about using AI tools and how they're used. Moving on now to the principle of fairness. It's crucial to keep the principle of fairness in mind when you're procuring and deploying AI tools in the workplace. So, for example, you need to carry out impact assessments, and that's to ensure that the system is accessible for all applicants and it doesn't unfairly disadvantage individuals with protected characteristics. And there's going to be a bit more on that later. So bias audits and performance testing should also be repeated at regular intervals after the system's in operation, and that's to ensure consistent performance and to assess the inputs and the outputs of algorithmic systems to identify any new or recurring bias or inaccuracy, which were two of the main risks that came up on the slide. So Richard, do you have anything to add here, or what are your comments on accountability?
Yeah, accountability. This is really a cornerstone principle of data protection laws, but also I think more broadly relevant for the responsible use of AI in recruitment. And this principle is really about not only complying with legal standards and requirements, but also demonstrating compliance actively. And in practice, what does that mean? Well, that means things like documenting what data you're collecting and how that data is going to be used, documenting, what third parties are going to be receiving the data and what protections you've put in place to ensure that the data is processed legally and responsibly by those third parties. It also includes things like documenting your impact or risk assessments regarding the use of AI software, and ultimately demonstrating how you are responsible for the decisions and outcomes that you make during the recruitment process, particularly where those decisions and outcomes are based on or influenced by AI technology. And we're going to be talking around some of the measures and assurance mechanisms that you can implement that will help to address this accountability principle. But it's definitely one to flag. And not only is this really a cornerstone of data protection, like I mentioned, but this is increasingly going to be an important principle under some of those AI laws and regulations that Hannah mentioned earlier as well. That said, let's move on swiftly. We're now going to talk about rights, Hannah.
Thanks, Richard. So moving on to rights, as we know under the GDPR, data subjects are granted certain rights when it comes to their personal data, including, as Richard's already mentioned before, the right to access, delete, and correct their personal data. But additionally, employees have a right to not be subject to automated decision-making. Under the EU Equality Act, which Maura's already mentioned as well, rights to this also include protection against discrimination, both direct and indirect, and ensuring barriers are removed for disabled individuals to accommodate accordingly. So this ultimately means an automated decision and/or profiling by an AI recruitment tool could impact an individual's access to employment opportunities, for example, by being discriminatory and as a result would not be in line with ensuring their right not to be profiled. Any decision that is solely automated allows an individual the key right to request human intervention to review and reassess the decision, as well as contest the decision if they believe it was unfair or incorrect, again, and request it be reviewed by a human. And this applies even if you can rely on any of the exemptions under Article 22. So if your business falls under this bracket when recruiting, at the offset, it should be ensured that there's a clear line of human intervention involved with the deployment of the AI recruitment tool to prepare for any said requests from prospective employees. But this should also remain continuous, so continuous monitoring and auditing of the tool to ensure outputs are fair and not discriminatory. Employers should also seek to reiterate prospective employees' rights in the recruitment process and ensure that this process for an individual to make any request is relatively simple. It should be noted that critical decisions such as rejecting or advancing candidates should be ultimately reviewed by a human recruiter. AI should mainly just assist in the initial stages, but final decisions should ultimately involve human judgment. And moving on to some other additional rights that are quite important and very topical. DSARs, so applicants, candidates, and other individuals have a legal right to formally request information about and access to personal data which an organization holds about them. And this includes data submitted in applications, notes from an interview, results from assessments, and any other relevant data processed during this recruitment process. The aim is to help individuals be aware of and verify the lawfulness of the processing of this personal data, but in practice, we're often seeing it's used as a prelude to litigation. So we therefore suggest it's important for creators of AI systems to consider how to develop the AI system in order to comply with this DSAR right, and for employers as users of an AI system to consider how well the system can respond to these requests. And now I'm handing over to Richard to chat about lawfulness.
Thanks. So the last key principle we have on the slide is lawfulness. And I guess this really ties everything together because naturally you want to ensure that your use of AI is lawful, but also in particular under the GDPR, you actually have to establish a lawful basis for the processing of personal data. And in the context of recruitment and where you are collecting and processing candidates' information to assess their suitability and to make decisions about their application, you're most likely going to be relying on the lawful basis of legitimate interests. And to rely on this basis, this really requires a careful balancing test to ensure that your interests, your commercial, business, and operational interests do not override the rights and freedoms of the data subjects involved. So, for example, if you're using AI to screen job applicants, you have to be able to demonstrate that the use of AI is necessary to achieve your objectives, such as to improve hiring efficiencies or ensuring better matches for job positions, and demonstrating that those interests and benefits are not outweighed by the potential risks to the applicant's rights. And that balancing test is really going to consider all of the other things that we've been mentioning so far. So issues like transparency, fairness, and rights. So that gives you an idea of some of those key principles.
So get your phones out again, guys. We've got the final Slido. So input all your answers, but what do you think are the most useful AI recruitment tools? And then we're going to discuss some of the results that pop up on screen. This could be things you're using at the moment or things you might perceive your business want to use in the future. Yeah, anything you think relevant. Okay, so we're getting a few results in now. So video analysis, yeah, it's another key way, interviewing and use of video interviews. CV scraping tools, yeah. Resume screening and job posting description, yeah, those are very, very useful and very popular for reviewing masses of CVs. Onboarding automation, yeah, streamlining the process to allow more prospective employees to onboard.
Yeah, and some of these are really focused around improving efficiency and streamlining existing processes, like, you know, the fact that you might have a huge amount of CVs to process, and therefore you are looking for technology to help deal with that volume of applications. Or maybe you're looking for tools that can help provide additional insights or analytics regarding the candidates that you're reviewing. So looking for technology to augment and supplement your own human review. So lots of different types of capabilities.
Yeah. So thank you all for your input. All really good and key recruitment tools that we've seen being used. I mean, other that we will chat to later, things such as chatbots. You've already mentioned job posting tools. But in order to hone in on some of these tools that we've been discussing, we're now going to discuss them in depth. And we go to the first one, which is sourcing. So the main AI sourcing tools, as you can see on screen, are job description review, headhunting software, targeted advertising, and recruiting chatbots. But starting with some key ones, I'll go to job description review software. So what is this software? This software encompasses software used to assist businesses to construct, manage, and store job description information. So key features include analyzing text, keyword optimization, and regulation compliance. So it's essentially aimed to ensure that a job description is accurate, in line with what an HR department would require from candidates, and ultimately what attracts good talent. We also similarly have headhunting software, which is used to help recruiters search for relevant candidates via, again, keyword searches or more complex candidate searches. However, when using these, there are legal risks involved, such as how things are worded can provide inherent issues surrounding words that may increase bias and dissuade candidates from applying, which would not be in line with the Equality Act due to being deemed discriminatory. And we're seeing increased input from the Equality and Human Rights Commission, and they have cited their role in 2024 and 2025 will see more predominant focus on reducing and preventing digital exclusion and the use of AI in recruitment practices. So it's key to have this on your radar if your technology has any risk of bias. And headhunting software has a similar set of biases, just this fixed idea of what an ideal candidate can dissuade certain people from applying. And now we go to targeted advertising. So what is targeted advertising? It's the technology used to source the most suitable candidate for the job by essentially profiling certain job adverts to ensure candidates with the right skill set are exposed to them. But again, the legal risk here is with profiling due to being based on likely protected characteristics, has the ability to dip into long-standing biases such as a gender-based role and using words that are typically associated with a gender to get that gender involved. And there may also be widening socioeconomic biases if you target specific geographical locations, which would impact which racial groups are exposed to said advert. And lastly, recruitment chatbots very quickly, which are essentially AI chatbots used to guide candidates through a recruitment process. And Inherent risks, as with any chatbot, are the data they're trained on, in which you need to look at the data set, make sure it's not irrelevant, insufficient, or inaccurate, as the output is then likely to be wrong or illegal. Heading over to Moira, who's going to discuss screening tools.
Great, thanks, Hannah. Yeah, out to the main AI tools that we use for screening applicants. So first I'm going to look at CV matching. So what's that? Well, it's where a screening tool, also known as CV scraping, extracts data, key data from CVs or resumes to find semantic similarities between applicants and predetermined ideal CVs or resumes. And so what are the legal risks here? Well, there's the risk of perpetuating existing bias. So, for example, this could be reinforcing patterns of underrepresentation of protected groups, which is most typically women, ethnic minorities, and disabled people. And this risk is particularly strong in less diverse sectors. So this could lead to claims for indirect discrimination, where somebody with a protected characteristic suffers a disadvantage because of a screening tool's algorithmic output. So an example here is where Amazon had to scrap an automated CV screening AI system when it became apparent that the AI favored male CVs and rejected female CVs. And the reason here was because the underlying models had been trained on more than 10 years worth of data, which showed the CVs of Amazon engineers were largely white male. So as a result of this, the system produced discriminatory outputs. And this inherent bias would risk discrimination claims from all female applicants, so a substantial group potentially. And that would be on the basis that the placed women at a substantial disadvantage because of their sex. In the UK, in order to defend a claim like that, the employer would need to show that the use of AI was a proportionate means of achieving a legitimate aim. And while the use of technology to streamline the recruitment process could be a legitimate aim, potentially, it's quite difficult to see how such a tool, which can have significant implications for a candidate, could be a proportionate means of achieving that aim without any human oversight. So in that particular case, the bias was quite visible, but in other circumstances, the algorithm's decision-making criteria might be quite opaque to the individual who's reviewing it and who's applying the decision. So the discriminatory basis of the decision might not be evident or easily rectified. And that's why it's important to do a bias audit and also to understand the tools that you're using. So moving on to another tool, looking at psychometric testing. So this is where AI-powered games and assessments can be used to measure cognitive skills, including problem solving and working memory, as well as job-relevant personality traits. And some of the risks here are tests lack scientific validity, and that's whether they're AI driven or not, and the outputs can lack reliability, and this risks arbitrary recommendations being made about candidates. Psychometric tests might also be inaccessible for neurodivergent applicants, so reasonable adjustments must be available, and that could include alternative assessment or an option to opt out. So finally, I'm going to move on to qualifying screening tools. So these include automated screening, sifting, and ranking tools, which evaluate CVs and personal statements and assign them a score. In most cases, the tool will score candidates using keyword search results based on criteria defined by the employer. And the legal risks here are that screening tools are often they're often trained using historical data. So this is similar to the Amazon case I mentioned earlier. And this creates a risk that the system might inherent bias from past recruitment practices, or it could use proxy indicators for success that aren't actually relevant to a position. Also, it could regard gaps in employment in a negative way, and that would typically disproportionately impact parents, carers, and those with disabilities, including neurodivergent individuals or those with long-term health conditions who have needed to take justifiable breaks from work. And that concludes the screening tools, and I'm going to hand over to Richard now.
Thanks, Moira. So now we're moving on to the next stage, interviewing. And we know that there's a number of different tools out there now which are specifically designed to supplement and help the interviewing stage of the recruitment process. And in particular, we're seeing increasing number of video interviewing tools or software which incorporate technologies like facial recognition and emotion recognition or sentiment analysis. And what these tools are really designed to do is analyze the emotional content and reactions of a candidate during a video interview. So looking at things like speech, facial expressions, and body language to assess the candidate's mood, sincerity, or maybe compatibility with team culture. So for example, systems that use eye detection as a proxy for engagement. Now, while the scientific validity of some of these tools is still up for debate, they also can present significant legal and ethical risks. So for example, studies have shown that facial recognition technology often has lower accuracy rates for non-white faces, potentially leading to misidentification or misinterpretation of facial cues. There are also accessibility concerns. So for example, individuals with certain disabilities or those who naturally exhibit less expressive features may be unfairly assessed by these tools. And naturally, we also have unfair bias. So different cultures express emotions differently. Particular people from different cultural backgrounds may consider direct eye contact as inappropriate or disrespectful, while neurodivergent individuals may find it more difficult to maintain eye contact. And additionally, there are some privacy concerns, particularly around the collection of sensitive biometric data, which is subject to additional obligations under the GDPR. And you actually have to establish one of the conditions under Article 9 to collect and process somebody's biometric data. So suffice it to say, these kind of tools are a real particular area of risk, and they cut across many of the issues that we've been talking about today. And lastly, I'll just mention briefly transcription tools as well. So these are tools which translate or transpose voice recordings from interviews into text data. And there are software and tools out there that are used to review responses within transcripts and assess those responses automatically. And obviously, these types of tools can exhibit bias as well, particularly if transcription tools are less capable of recognizing regional or non-native speakers or accents, etc. So, having discussed the various risks associated with AI recruitment tools, it's clear that merely recognizing these risks is not sufficient. We actually have to do something to address them. And this really brings us to the crucial part of our discussion today, and that's around some of the risk mitigations and what are often termed assurance mechanisms that you can implement to identify and mitigate and potentially even eliminate some of these risks. Let's take a quick look, first of all, at the life cycle. So this slide is actually presenting a diagram from the UK government publication called Responsible AI in Recruitment that was published in March this year. It's quite a useful diagram for giving a representation of the life cycle of the adoption of these technologies and where these assurance mechanisms lie within that life cycle. So for example, we have before procurement or the pre-procurement stage, and this is really about setting the groundwork, so establishing some of those government mechanisms that you're going to be using and defining the legal standards and also ethical standards that are going to guide your implementation of the tool. And then we also have during procurement. So while you're in the midst of the procurement phase, thinking about specific insurance mechanisms that you can rely on to think about some of the risks, and we'll come to talk on about more of these in a little bit more detail. And as you can see, it scales up a little bit during post-procurement and live operation. I think one key takeaway from this slide really is that not only are some of these assurance mechanisms going to be crucial at the early stages of procurement and before you're actually engaging with a vendor, but they might also need to be revisited later on during the life cycle and as the system progresses. And that includes both once you're operational and you're using the tool, but also for ongoing monitoring and ongoing auditing of that tool to make sure that it still complies with and aligns with both your business objectives and your legal obligations. Let's now turn to talking about some of those specific assurance mechanisms that you can look to implement. So here's a key one, and this is quite early on, which is if you are procuring an AI tool from a third party, you naturally have to do appropriate due diligence of that provider and the tool that you're looking to implement. In particular, suppliers might make claims about the performance, ROI, efficiency and fairness capabilities of the system that they are selling. And you're going to be thinking about, well, what's the evidence to back up some of those claims? So you're going to be asking the supplier for documentation around, well, how can you evidence the accuracy or fairness of your system? Has the supplier conducted any assessments of their own around the impact or risk of implementation of that system? Can the supplier provide things like model cards or any other kind of codes of practice or industry standards to evidence how they've complied with some of these requirements? Another important assurance mechanism is going to be consultation with employees. So actually talking to the people who are going to be using and relying on this technology to understand how it's going to be most useful and effective for their role. And also alerting them at this stage to whether the use of that tool is going to be appropriate and highlight some of the key legal considerations to think about. And part and parcel of that later on is also going to be about training users. That's both training on the intended purpose of the system to ensure that there's no scope creep and that the system is going to be used solely for the intended purpose and not going to be misused or used irresponsibly, but also to ensure that employees understand how they can make the most of that tool. They understand the outputs of the system and their role in reviewing those systems and not relying on them heavily. So providing a critical lens to some of the decisions or recommendations that have been made. You might want to accompany that by something like a responsible AI policy. Perhaps your organization already has adopted or published a responsible AI policy, and that's going to provide some key principles and guardrails around the use of any AI technology, but particularly important in the context of recruitment. Coming to a little bit later on, we're also going to be thinking about active monitoring of the tool once it's implemented. So this is going to involve things like ensuring that you're collecting and incorporating feedback, not only from employees who are using the tool, but also looking to obtain feedback from candidates who are actually engaging with these systems to make sure that the system is actually working as intended, but also to try and spot any particular issues that arise during the actual implementation stage. Another really important one is ensuring human oversight and that there's human in the loop whenever using these type of tools. And that's particularly relevant when we think about things like automated decision making, because we know that's a particular area of concern. There are additional legal hurdles to overcome, and ensuring that there's a human involved there might help to negate some of those legal triggers for automated decision making, but also to make sure that there's actually some level of oversight and fairness that's being integrated, and that you're not wholly reliant on the AI's recommendations or outputs. Another key thing we've got on this slide is thinking about documenting your assessment. Now that could take a number of different forms. So increasingly companies are starting to implement algorithmic impact assessments, and these are really going to be used to think about the potential impact and risks where you're using AI tools more broadly, and that could be for a range of different types of risks. We might also have an equality impact assessment, which has a slightly different angle to the algorithmic one, and that's more focused on whether there is equality and fairness outcomes by using the system. And Moira, do you have any additional comments on this type of assessment?
Sure. So I think for an equality impact assessment, it's important to review the system for any potentially unfair practices. So this could be looking out for non-inclusive language, for example, or practices, and also ensuring that the system's been tested, or where applicable, it's been trained on a wide demographic. So it's been tested on all of the various protected characteristics to make sure that it doesn't unfairly disadvantage them. And then separate to the equality impact assessment is also a bias audit, where you're going to be looking at the data input and output to make sure that it doesn't include bias or sort of have an outcome which has unfair bias. Oh, sorry, and also, as part of that, you should also plan your reasonable adjustments. So they should be considered really early on, and you should test the tool to make sure that you will be able to put reasonable adjustments in place.
Fantastic. There are a couple of other assessments that we've got on screen as well. So data protection impact assessment. This isn't actually a recommendation. This is a legal requirement. If you're using new technologies like AI in a high-risk area such as recruitment, you're going to have to complete a DPIA, and that's specifically focusing on the data protection risks regarding the collection and use of individuals' data. And related to that, I mentioned earlier the lawfulness principle, and that's the need to establish your lawful basis for processing under the GDPR. And where you're relying on legitimate interests, you should also be completing an LIA, or a legitimate interest assessment, that considers the balancing test that I mentioned earlier. And you might decide to do that as a standalone assessment, or that actually could form part of your DPIA as well. I think what's important to note is that there's not necessarily one size fits all when we're thinking about some of these assurance mechanisms and how you implement risk and impact assessment. You may already have existing processes in place in terms of procurement, in terms of legal compliance and privacy processes and risk assessments. So it's rethinking and looking about how the use of AI recruitment tools is going to fit in with your overall processes as well. And I think all of this can really be form part of and connects to broader AI governance as well, Moira.
Yes, that's right. So I think early on, it's important to develop an AI governance framework. So in that, you're going to set out how the AI is going to be embedded in the organization. You'll have a risk management framework, and it's important to assign who's going to be accountable for that AI system, and somebody with the relevant knowledge and skills can hold that position. And also it would be helpful to create methods for escalation as well. And as part of that, it's worth reviewing your existing policies. So that could be your code of conduct, acceptable use of IT, data protection and privacy policies, and also consider introducing new policies. That might be specific AI policies if you don't already have them, or other policies specific to the tools that you're using.
Fabulous. So we've talked through some of the specific assurance mechanisms. We're coming towards the end of the webinar now. So we thought we would leave you with some key considerations. So this is where we take a step back, we breathe a little. We know that there are risks, we know that there are legal considerations, and we know that there are specific measures and mechanisms that we can implement to address those risks. But now let's just think about when you are procuring, implementing, using these types of softwares, what are some of the key questions and considerations that you need to think about?
Yeah, thanks, Richard. So as Richard mentioned on the slide, these are the key questions you need to think about when you're using the AI, such as why you're using it, the use case, and the training requirements. But if we fit this back into the recruitment lifecycle and look to before procurement, you should start considering whether AI is appropriate for the problem you're looking to solve. So ensuring there's a clear purpose and lawful basis, as Richard has mentioned, for the use case by carrying out a DPIA, which, as we said, is a legal requirement. Consider what outcomes you want the AI system to produce and why and how. And also ensure you're able to maintain effective human oversight of the system and its outputs, and consider how you'll do this on a practical level. Handing over to Moira to continue the recruitment lifecycle.
Thanks, Hannah. So yes, pre-deployment, consider what additional educational resources, training or skills might be required to support your employees. So Richard's already mentioned this, so check that your employees or those who are going to be using the model understand the scope of the model and the limitations of the tool. Consider whether introducing technology into the recruitment process amplifies any existing risks at scale. For example, does it entrench or perpetuate human biases? And that's going to be part of your impact assessment that you're going to do before deployment. And then when you reach the stage of live operation, you're going to consider, has your supplier set up a regular testing schedule to measure the AI system and to measure its performance over time? So there could be errors, there could be bugs, or something called model drift, which is a phenomenon that sees model performance decay over time due to changes in real world environments, input data, or underlying model goals. So you need to ensure that there's ongoing monitoring, there's performance testing, and that there are bias audits perhaps every 6 months or when changes are introduced to the system. And that's to ensure that the system continues to perform as expected and as you intend over time.
Thanks, Moira. So wrapping up, unfortunately, we don't have any time for questions, but if anyone has any questions, feel free to email us or send us a message on LinkedIn. We're more than happy to help, and we hope you've enjoyed the session.
Absolutely, and please look out for our next webinar. Hopefully you're on our mailing list already, but if not, please let us know if you'd like to be added to our mailing list, and we will be obviously providing more webinars over the next few months. The details aren't there yet, but we're thinking about doing a mini series or a few webinars on the AI Act, and obviously that's going to be important for AI use in recruitment as well. So that might be relevant and interesting to many of you today. Thank you for listening. We really appreciate you tuning in and taking the time out of your day to join us. Hopefully you found this helpful. If you have questions, feedback or comments, let us know either through LinkedIn or by email. Very, very happy to hear from you. Thanks for joining, and we look forward to seeing you again next time. Bye-bye.